A Cook Islands trust can protect your domestic assets from litigation, lawsuits, and judgments. The reason is that it allows you to transfer ownership of the asset to a foreign trustee company that will then hold the assets for your benefit. In fact, under Cook Islands law, they have a fiduciary obligation to hold it for you under the terms of the trust agreement. The trust agreement is something that would be drafted by your U.S. asset protection attorney under provisions that will be upheld and recognized by U.S. courts as actually protecting your assets from creditors. Once the asset is transferred offshore, there's nothing that a U.S. creditor or judge can do to actually collect on the asset to satisfy a money judgment. Cook Islands trustee companies are forbidden by law from giving legal effect to the U.S. court orders or creditor actions. In fact, in over 40 years of Cook Islands Trust being formed, in not a single time has a creditor actually been able to force a trustee to willingly transfer over any assets subject to a judgment. In some situations, when an asset is transferred after a legal issue has arisen, transfers could be attacked as fraudulent conveyances. This matters more for assets that must remain in the U.S., such as real estate or local companies that have been formed under U.S. law. For liquid assets, it is still very difficult for a U.S. creditor to actually collect against the assets once they are owned and controlled by the trustee company.